Reflect that everyone is here, including Mr. Terry. We left off with the defense case and more witnesses.
Yes.
Also the possibility of redirecting Mr. Terry, Mark Terry.
He's still under potential subpoena.
Okay. All right. Well, it's your...
Let me just check to see who is here.
Sure.
I know we have some witnesses here, but let me see.
Oh, let me check on the jury. All here? Very good. I figured I'd hear otherwise if they weren't.
They're not in their coordinated public lunch break.
Wait, some of them were coffee yesterday. I was worried.
No, I was.
Is the defense ready?
Yes, sir.
Is the state ready?
If you have something to address, it's fine, but I don't know if we're prepared to give an answer yet. But go ahead if you want.
Yeah, I'll go ahead and do it. Judge, there's a matter that's come up that I kind of messed up on. Remember yesterday when we talked about the introduction of the transcript of Kay Baker in the Michigan trial? And
Yes.
we had an argument about that. Well, we had a discussion about that.
Right.
And
I think there was a concession by the state.
the concession by the state is that all we're going to do is establish that Kay Baker testified, traveled to Michigan, testified in the trial on behalf of the defendant.
Right.
That's where it was going to end.
Right.
I forgot to remind Mr. Diaz to ask that question of the prosecutor yesterday. So that question, that single question wasn't asked. So now, as I reviewed the record yesterday, although Mr. Diaz presented it in his opening statement, that question was not asked of the prosecutor. So it's left hanging out there. So technically speaking, it's not in evidence. And so I was just trying to see if we can resolve that. The prosecutor is still here. Can be called to the stand to ask that single question to establish that. And I just wanted to let everyone know about that outstanding issue and see if we can resolve it.
Judge, they have closed their aggravation case. If they failed to ask something that is on them, we would object to them reopening their case in aggravation in the middle of or after our mitigation case.
Any authority? Either way? You want some time? I don't have to decide this right now. We can get rolling with the defense witnesses that are here. The prosecutor going to be here for a while?
She's seated in one of the witness rooms. She's working on her cases from Michigan, so she's
Okay.
happy to sit for a bit.
All right. I appreciate you giving me the heads up. We'll do research. I appreciate any authority. I always like authority. So, defense, you have authority that suggests that I shouldn't let him open the case. I want to see it. State, you have authority that suggests I should allow you to open the case for that one limited purpose, I want to see it.
Yes, Your Honor.
All right, thank you. I appreciate it. Other than that, anything before we get to jury?
Not, well, Your Honor, just nothing.
Thank you.
For purposes of the record, it was my recollection yesterday that Mr. Kane admitted the pen pack. I checked with the clerk this morning. She says that she does not show it as actually admitted.
Okay.
So Mr. Kane says he's not admitting it.
Okay.
I thought it was admitted. Apparently it is not, so it's not coming into evidence as a physical object. If the record should reflect different in the future, Mr. Kane is now not putting it into evidence if he did previously say admitted, and Your Honor did say it was admitted for the record.
I honestly didn't remember. I mean, there was some stuff that was clear. I do remember the certificates and stuff like that, but I trust the clerk. The clerk does a real good job over there. So
I agree, and the clerk's record is what matters, so I defer to that.
okay. All right, you ready for the jury?
Yes.
I know you've said yes 3 times now. I'm waiting for the state to say yes.
We're ready, Your Honor.
Let's get the jury. Thank you, Mr. Kane, though. I appreciate it. Appreciate you answering my questions. Can you tell us who your first witness is going to be?
Aubrey Land.
I'm sorry? Oh, Mr. Land, Aubrey Land. Does he have a title?
Mr.
That's what I'm going to use. That's the default. The door so that when they call him, he's ready to come on in. That'll be perfect.
All right, jury in report.
Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, good morning. Welcome back. Happy Thursday. Nice to see you all. First question, as always, by show of hands. Anyone exposed to anything about this case outside of the courtroom between the time you left yesterday and the time you returned this morning? Thank you. Let the record reflect there are no hands. Anyone discuss this case amongst themselves or with anyone else between the time you, well, any time, discuss this case other than deliberations, but particularly since the time you left yesterday and the time you came back this morning? No hands. Let the record reflect. And finally, anybody do any research related to this case by show of hands? Again, thank you very much. Let the record reflect there are no hands. We're going to pick up where we left off, and I'm going to turn to the defense and ask them to please call their next witness. Aubrey Land. Mr. Land, good morning. Welcome. Wherever you're comfortable, if you'll face me and raise your right hand, please. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
Thank you, sir. If you'll follow the bailiff down to the ramp that leads up to the witness chair, please watch your step. Go ahead, have a seat in that chair. Make yourself comfortable. There is a microphone there. It's fully adjustable, and the green light is on, so it is all ready for you. You let me know when you're ready, and then I'm going to turn it over to the attorneys to ask you some questions.
I'm ready, Your Honor.
All right. Mr. Kane, you may proceed.
Thank you, sir. Good morning, Mr. Land.
Good morning, sir.
Would you identify yourself?
My name is Aubrey Perry Land, Sr.
What is your occupation?
I am a retired corrections and law enforcement professional. I am now doing private work in sentencing cases, cases involving inmates, and issues of that nature as a consultant.
All right. I might ask you to speak up a little bit. I know the microphone amplifies, and you just want to make sure everybody can hear you okay. So
And I apologize in advance. A little difference in elevation and seasonal allergies as well. So,
All right, we all sympathize. Can you tell us a little bit about your history and your work experience and how you came to the profession you are now in?
well, I did 33 years of law enforcement and corrections, about 50-50 each. Started off in corrections and ended my career in corrections. Worked as a correctional officer, sergeant, patrol officer, detective, homicide investigator, narcotics investigator. Last 10 years of my career, I served with the Florida Department of Corrections Office of the Inspector General as a senior law enforcement inspector. When I retired in that capacity, I pretty much so worked every facet of the Florida Department of Corrections, either investigating it, being directly involved in certain programs and things of that nature.
About how many different facilities have you worked in?
Most all of them, in some fashion or another, whether it was going in, doing investigations and interviews and things of that nature, or reviews of the facility.
Have you had interactions with wardens and assistant wardens of these facilities?
Most every facility,
You've had inmate or prisoner interactions?
thousands.
Have you also become familiar with jail facilities?
Yes, sir, I have.
What's the difference between a jail and a prison?
Well, in most cases, a jail is, pretrial. There may be some inmates that are, sentenced to a misdemeanor offense for a period of time in there. The state-run facilities are mainly for convicted people who have been convicted of felonies. Their housing assignment is somewhat different. Classification of the inmates to determine where they fit in at best, their work assignments and things of this nature.
If I heard you correctly, you have about 33 years of experience in corrections.
Correct, yes.
And about how many prison facilities have you worked in or become familiar with?
Directly assigned to probably somewhere around 10. As far as worked in, 25 or so.
You've testified in courts of law before?
Many, many times.
Have you testified in your capacity as a law enforcement officer?
Yes, sir, I would say hundreds of times.
About how many times have you testified in your capacity as a corrections consultant or expert in the field of corrections?
In this environment, I would say probably, I'd have to go back and look, but probably around 25 times.
Tender the witness.
No questions.
You're often called upon by various parties. I don't know if you've ever been called by the state. I don't know if obviously you've been called by the defense before. Here you are today to offer expert testimony about a particular person and that person's amenability to the prison environment. Does that sound accurate?
That is accurate.
And how many state courts have you testified in?
Well, here in the 13th, probably 5 or 6 times, maybe as many as 7. West Palm Beach, Volusia County, Duval County, the First Judicial Circuit.
How about different states?
Sir,
How about different states?
the state of Alaska.
Different countries?
Actually, I haven't testified. I have worked some cases in other countries.
When you're called upon by the defense, for instance, when you're called upon by the defense to offer an opinion about somebody's amenability to the prison environment or corrections, do you always offer a favorable opinion?
No, I have been retained on several cases, and
talked about the word analysis here. You mentioned a review of various records when you're looking at a particular person and how you believe, as an expert, they might respond to a prison environment. What are some of the things that you look at? What are some of the criteria you may consider in that process?
Well, there are many things to consider, especially in the classification of where that person would fit in. A lot of it would be their overall behavior, whether they have complied with the rules and regulations of the jail setting that they may be in, prior committals into a facility, what their educational background is, their willingness to want to work, and different things of that nature.
Tell us about the classification system in the prison environment.
Well, as an inmate is received into the Florida Department of Corrections, one of the very first things that will happen with them is we will do a classification review of that individual. One of the things will be the sentence itself, whether it be a life in prison sentence, a death penalty sentence. Things of that nature is going to determine where that person goes to. And then the classification goes much further than that. We have to determine a security level for that individual. Let's say if they are serving a sentence of 25 years, where would they best fit in at within our system? Well, that individual would be a higher risk inmate, so he's going to be a close custody to maximum custody inmate. We're going to take into consideration his jail record. We're going to take in consideration whether he has complied with the rules or not. And then we're also going to look at his education level and his professional work history to determine the housing of that individual.
Have you met with Mr. Terry?
I have.
How many times have you met with him?
I met with him once, and that was back on October the 12th. I sat down with him for about 2 hours.
What records have you reviewed, or what documents have you reviewed in this case?
Well, I have reviewed a little bit of his military history, his release from the military. I reviewed somewhere in the neighborhood of 350 pages of documents, a committal in another state, and his jail records for here in Hillsborough County.
And were you also provided college transcripts?
Yes, I was.
Now, when you mentioned that you have interviewed or spoken to thousands of inmates, right?
Yes, sir.
And about how long would you say, just in your experience, how long would you say it takes you to pretty much size somebody up and know whether or not they're going to be a problem or whether or not they're going to be less of a problem? How long would you say it takes you to do that?
Well, the initial review of that, you have to do it pretty quickly because we do process so many different people. We talk to so many different people. So we have to kind of sum a person up pretty quickly. But then, it's not just what we come across with our impressions of that individual, how that person communicates with us. We also have to go back and do a document search on that, kind of verify. It's trust but verify. Sometimes people just don't have good communication skills, and you have to dig a little deeper. Some people have excellent communication skills, so it's an individual basis, but we do that rather quickly, but then we verify.
Right. So when you met with Mr. Terry, you had your initial impressions, right?
Correct.
And then after a couple of hours, you had further impressions of him, correct?
That would be correct.
All right. Now, was anything proven or disproven by your document search?
Well, the biggest thing was explaining my opportunity to sit down with Mr. Terry is he has excellent communication skills. Was very open about anything that I wanted to talk to him about. Straightforward. I didn't get the impression that he was trying to withhold any type of information from me. The documents that I had reviewed revealed that he was being honest with me about the information that he provided to me.
Were you at all familiar with the facts of the case?
I know some of the facts of the case. In my line of work, knowing everything that a person has done is not necessarily important. I need to know some of it. But details, no. I didn't know all the details of it. I still don't know all the details of it. I know that he's charged with one count of premeditated murder. I have looked it up online and saw a little bit of that information, but all the details, no, I do not know all of them.
No. To what extent does what a person's been convicted of inform a DOC professional on how that person can be expected to conduct themselves in prison? So you have, let's say you have somebody convicted of drug dealing, and then you have somebody convicted of murder. Can you tell just from those charges alone who is going to be the better inmate?
Not always, but as a pretty well rule, inmates who are charged with homicides are less likely to cause a problem for correctional staff than someone who is convicted of a drug crime. Because one of the things that we have in prison is an influx of contraband and drugs coming in at an alarming rate. So many times a person that is addicted to illicit drugs and things of that nature, they will continue to violate those rules in the prison system, where a person that got mad and committed a violent crime, they may just be a one-time incident with that individual, and we don't have that outburst in our system. We just basically house them for the period of time that the court tells us to keep them.
You're aware that Mr. Terry also served a sentence in the Michigan Department of Corrections
That is correct.
for an offense against a woman that involved a knife.
That is correct.
And this case involves an offense against a woman involving a knife.
That is correct.
Is that any sort of concern for DOC, the fact that he has a repeated offense of a similar nature?
The offense is not something that is concerning. His custody level will be maximum security. I need to give you an analogy. If he is sentenced to a life in prison, he is going to be a maximum custody inmate. He is going to be assigned to a maximum custody housing unit. That is where we are going to do more thorough searches. We are going to monitor him more closely. His movement around the prisons and things of that nature would be more closely monitored than someone that is serving a 5-year sentence for grand theft.
Talk to us a little bit about the distinctions when it comes to employment requirements for somebody serving a life sentence versus somebody on death row.
Well, if I understand the question correctly, if a person comes into death row, it doesn't matter what his work habits are, what his educational level is, or anything of that nature, because we're not going to employ him.
Right. So the distinction is that death row inmates do not work.
That is correct.
And tell us about what the work requirements are for somebody serving a life sentence, even in maximum security.
Every inmate in the Florida Department of Corrections has a job. That job could be sweeping shadows off the sidewalk, or it could be cleaning a housing unit. It could be a plumber, carpenter, a cook, washing dishes, washing laundry, just according to where that person fits in. And then you also have people that are incarcerated and have very high IQ. They have a good work record coming in. They have professional skills that can be utilized by the prison system.
Where does Mr. Terry fit in all that?
In the latter end of it, he is educated. He has I believe, a bachelor's degree. He has a good work ethic. He has excellent skills that in today's Department of Corrections would be very sought after.
What is the benefit of somebody who is a software engineer with a computer engineering degree? Where might they find a place in DOC in terms of employment?
Well, I'll give you an example. It's like all of the tolls that are collected throughout the state of Florida. That is, most all of that is entered by inmate labor.
Every time someone goes through a toll and it reads a toll on any sort of expressway, then that transaction goes to the desktop of an inmate?
That would be correct.
And how does that work? What are they doing, and how is that information processed?
Well, to sit down and tell you everything about how it happens, I don't. But I know that the pride industry, prison pride industry, they have, my understanding, the contract on doing that. And then they have inmates working in that program to where they're actually entering it and through the computer system.
Now, Mr. Terry's skills as a software engineer go beyond simply data entry. So how might those skills be brought, and to what benefit might that be to DOC?
Well, one of the things that I didn't really get a chance to sit down and talk to him about, and I intended to come back and see him a second time, is for him to do a resume. Because that would be information that would be very important to a classification officer when he comes in. Now, they would enter that information into the CDC program at the facility, and then Pride is going to see that. So if he was sentenced to a life in prison, I would fully expect that Pride would know that really quickly. They would seek him out, whether placing him in the actual Pride unit where that type of data is collected and billed out, or whether it would be to train other people how to do that. So his skill set would be in very high demand.
Where there is not somebody with a skill set within DOC to fill that position, what is DOC's alternative?
It would be to hire a private individual to do that.
How much do DOC inmates make when they work?
It's been a little while since I talked to Pride, but the last that I heard, I think, was 75 cents an hour.
Which comes out to about what? Per
Well,
year?
the normal hours that they get to work, somewhere around $900 a year.
$900 a year.
Yes, sir.
Would a software engineer cost more than that?
considerably.
So what happens if an inmate goes on strike and decides not to work?
Well, you can refuse to work. You're going to go to confinement. You're going to lose any privileges that you may have. You're going to lose anything that you have worked up to, say, a good job. If you are working at Pride, you get a disciplinary report, you lose that $75 a month that you make, and you're sitting in confinement with no canteen, no privileges.
Is that otherwise known as close management?
Well, no, not really. A first-time offense would not put you in close management. However, if just say they tell you to go to work and you say I'm not going to, then there's a argument between the staff members and disrespect to official, then a refusal to do what they're telling you to do, get off your door, stop beating on the door or whatever. Now you got 3 or 4 DRs stacked up against you, and your time in disciplinary confinement has just increased drastically. We're not going to house you at that facility with 6 or 8 months worth of disciplinary reports against you. You're going to end up in a close management situation.
Now, refusing to work results in confinement. And what does confinement mean compared to, say, an inmate who's working regular hours and doing what he's supposed to do?
To give you an example of an inmate who is serving a life in prison sentence, that person is going to be in a 2-man cell, a secure type cell. They will be locked in at 11 o'clock at night. They will be unlocked and free to move around, or somewhere in the neighborhood of 6 o'clock in the morning. They will go to and from chow. They will go to and from work. If they have a medical call out or something of that nature, they will go to medical. An inmate that has been placed in disciplinary confinement or to see him, they will be in that cell 23 hours a day. They will be escorted anywhere that they go. They will not have any luxuries in there.
It sounds very close to what a death row inmate has to endure.
Well, to a degree, death row is locked in a single cell with just one person. They have their own TV. They have a iPad. They have access to their canteen. They have access to general population. The new protocols in death row is kind of like general population. They have certain amount of hours a day to mingle about the unit, watch TV with some of their friends, play board games, and have other recreation area.
And if I'm hearing you correctly, none of that involves employment.
None.
In some ways, it might be more pleasant than somebody who was in confinement serving a life sentence.
Correct.
In your review of the records from the Michigan Department of Corrections, did you see any disciplinary infractions or any disciplinary measures taken against Mr. Terry?
I have not.
In your review of the records of Hillsborough County Jail, have you seen any disciplinary action taken against Mr. Terry?
I have not.
From your review of the records, and what is your overall conclusion regarding Mr. Terry's conduct as an incarcerated or jailed individual?
he has been exceptional. You would expect some disciplinary from inmates when they first come into a system. Mr. Terry is a little bit different than that because he was in the military, so he has the authority he understands authority. So, and that's probably one of the hardest things that the Department of Correction has in a newly arrived inmate is getting them to understand that we have policies and procedures, rules and direction, and you're going to have to follow those. The military has kind of taken care of that in Mr. Terry's case. So he has done considerably well.
In your opinion, what is Mr. Terry's amenability to a life sentence?
I don't know how well he would sit down and adjust to it. I mean, that's an individual basis, but can he benefit the agency? Yes. Can he live in an open population setting? I believe so, with no problem. He has proved that previously. He has not caused any problem in the jail where he's at now. Actually, I believe that he has volunteered to work and has a job at the jail from my understanding. So I believe that he will fit in an open population rather well.
Based on your review of the records, you would have no concerns about his conduct?
No, sir.
And when you sat down and spoke to him, was he cooperative?
Very, very open about anything that I asked him about. And I want to say this, I never talked to someone in that situation about the crime that they are accused of having committed. But, sitting down, talking to them about family, talking to them about education, talking to them about, what type of job that they do, trying to determine if they get along with other individuals. That's pretty much in mind.
Was Mr. Terry in any way hostile?
No, he was very open, very pleasant, was willing to talk about anything that I asked him about.
Court's indulgence, please. Pass the witness.
Ross? Good morning, Mr. Lamb.
Good morning, sir.
I want to ask you a question. You said that the military has already sort of predisposed Mr. Terry to follow the rules.
To a setting of a prison type setting or jail type setting, I would indicate that he understands that we run it and we're going to run it our way.
All right, well, let's talk about the rules that he's been predisposed to follow. The rules that he's been predisposed to follow are don't break the rules, right?
I would agree with you.
Don't hit other people, don't hurt other people, don't do things that cause harm to other people. That's one of the rules, right?
I would agree with that.
I mean, even when he went to prison, that was still a rule. That's not just a Marine rule. The default rule in prison is don't hit and punch and kill and try to harm other people, right?
We have that rule, yes, sir.
So for a man who's already been to the military, for a man who's already been to prison, did he follow the rules?
I would assume me sitting in this situation testifying here today that the determination has been made that he was not following the rule.
Right, the determination has been made. He did not follow the rule. The first rule, don't kill other people. He didn't follow that rule, right?
That would be my understanding.
Okay, and he did that after having served a prison sentence.
That is my understanding.
So he got a real taste of what it's like, right?
I would agree with that.
Okay. So let's talk about where you talk about how he is, an attractive or valuable potential asset to the Department of Corrections. Do you understand what I mean?
Yes, I believe I do. That my opinion is that he would benefit the Department of Corrections.
And I'm not going to dispute that. I'm certainly not going to dispute that. I'm sure that any person that could help the state of Florida manage its affairs is always going to be useful to the state of Florida. Okay? But I want to ask you a question. He's useful to the state of Florida because he's educated, right?
Well, he has a skill set.
He has a skill set that he got because he's educated, right?
Correct.
And he's educated because he came from a good family who could provide for him, right?
I would agree with that.
Okay. So if he had come from a bad family and he'd had a rough childhood and he'd never been educated, he'd be less of an asset to the state of Florida, and therefore are you suggesting he's more deserving of death? We should let the privileged live and we should let the underprivileged die?
That
Objection,
is,
that was not his testimony.
Well, you can answer the question. I'll overrule the objection.
I would have to disagree with you on that. I have testified in many, many cases of this nature to where I have seen young men who came to prison with no education, 14 years of age, sentenced to a life imprisonment, and that kid didn't really stand a chance for anything. And they applied themselves in prison. They learned trades. One in West Palm Beach, for example.
And let me just, I don't want to interrupt you.
I may you asked a question, may I finish?
I understand. Sure, no, you can finish. Please do.
Okay. But, that young kid, 14-year-old young black male, he could have went any way that he chose to go. And he decided to get an education in prison. He decided to be a model inmate. He chose to write the judge who sentenced him to life and actually become pen pals with that judge, keeping him up to date on what he was doing, the education level that he was getting, the positive things that he was doing. And to my surprise, at that resentencing hearing, that retired senior court judge walked into court and testified for that young man. So I would not say that I would sit here and indicate that a young man that had the opportunity to get a good education is more useful than someone who is less fortunate. And what I would further offer in that is the Secretary of the Florida Department of Corrections, who I have a tremendous respect for, is trying to utilize as many inmates who can to help move people into that direction, give them the opportunity that they may not have gotten on the street, they didn't get in school, or they dropped out of school. And today, we're trying to reduce the recidivism rate in the Florida Department of Corrections. We're giving education to our inmates. We're giving them real life skills. We're teaching them job skills. And when they get out of prison, they're able to actually get a decent job, become a productive citizen, earn a living. Those are the things that we want to see happen to the inmate population in Florida.
Okay, but that's never going to happen here. Mr. Terry's never going to get back out. This is not a question of
We're
recidivism.
not talking about Mr. Terry getting back out.
I got it. But, that's what we are ultimately talking about. We're here to talk about Mr. Terry. So this is not a situation where Mr. Terry is going to become a success story and get back out into the world and get a job and become a productive citizen. We know that that's not going to happen.
That's not going to happen.
Okay. And you talk about the word opportunity, and you really said something great when you were talking about this kid that turned his life around, this 14-year-old kid. You said he made a choice to turn his life around, right?
That is absolutely correct.
Because the whole point of prison is to teach people that what you do has consequences, and you can make a choice to turn your life around after prison if you want to. Right?
That is absolutely correct, and I'd like to expand upon that if I may.
Well, sorry, but I want to ask you some questions, okay?
Objection. Allow him to answer.
Question, it ended with right. It called for a yes or a no answer, so overruled as the objection.
Mr. Terry had that opportunity. That time came. It came somewhere in late 2021 when he was completely released from the Department of Corrections in Michigan, right?
That is my understanding, yes, sir.
And 5 months later, 6 months later, he didn't turn it around, did he?
I can't say he has turned things around.
Well, I mean,
And that's not what I'm testifying here to today.
Right.
You know, we're talking about whether he's going to death row or if he's going to life in prison.
Thank you for saying that, because that's the next line of question I want to ask you. You talked about people on death row. And I think most people think that death row means you sit in a jail cell all by yourself or a prison cell all by yourself all day long.
Objection. Is there a question? Doesn't matter what the state attorney thinks.
Well, rephrase it.
Did you say that people on death row get a TV?
They have their own TV.
And an
They
iPad?
Yes,
And they're given time to get out of their jail cell and mingle?
that is correct.
And they're allowed to play board games?
Correct.
And I'm assuming they're allowed to go outside and see the sun?
Correct.
I mean, it's not like you sit in your jail cell 24 hours a day, you never talk to anybody, you never interact with another human being, is it?
No.
It's not like you have nothing to do all day long, right?
Correct.
If you're not on death row, what you actually have is you have more freedom. You just have more time to be out, more time to walk around, more people to talk to, right?
Plus you have a job that you're required to do each day.
I mean, people on death row have a job to do each day, right? Behave. Be good. Don't get in trouble. Because there are still consequences if you misbehave on death row, right? It's not like the people on death row can just do whatever they want, is it?
No, you can have your privileges taken away from you on death row as well.
I'm ready with the questions, Your Honor. Thank you. Redirect.
Mr. Diaz, over our objection, was permitted to ask you about deserving. All right, he was suggesting that your testimony was trying to give a message to the jury that somebody who comes from a privileged background or is educated is less deserving of death row than somebody who does not have an education and does not come from a privileged background. So my question to you, Mr. Land, is, because you were asked about the word deserving, do you think anyone is deserving of the death penalty?
The objection calls for an opinion, a personal opinion, not an expert opinion.
He opened the door, Judge.
Hold on. No. No, I don't think you opened the door. I'm going to sustain the objection.
Well, do you believe that Mr. Terry is less deserving of the death penalty?
Objection calls for personal opinion, not an expert opinion.
Wait till he finishes the question, but it certainly sounds like it. Do you want to finish the question without asking for a personal opinion of the witness?
In your expert opinion, Mr. Land, do you believe anyone is deserving of the death penalty?
Objection, Your Honor, that's a personal opinion. It's not what he's qualified here as an expert on.
Mr. Judge,
Hold on. Approach.
sure. Mr. Diaz had asked you a question earlier about whether or not you believed one person who comes from one background may be more or less deserving of the death penalty than somebody who comes from another type of background. Remember him asking you that question?
Yes, sir.
So I'm going to allow you to follow up and offer your expert opinion about whether or not you believe anyone is deserving of the death penalty.
I don't know if a person would be deserving of a death penalty or not. I don't know that I can really wrap my head around that, but what I can say is I disagree with the death penalty, and for this reason. I have many friends who have worked on death row. I've had friends who were wardens that carried out executions. A very good friend of mine, Ron McAndrew.
Judge, I'm going to object. I'm going to sustain. He's answered the question. This is, I'm going to sustain.
And so through personal experience and seeing things firsthand, you have developed your view of that alternative.
Correct.
So, now in reviewing, also I think you also mentioned on cross-examination that an example of redemption that had come from an inmate getting an education and then going on to improve himself, correct?
Correct.
Now, often those individuals have the benefit of tutors within the jail system, don't they?
And mentors.
Mentors. And in your review of the Michigan Department of Corrections, did you see that Mr. Terry had functioned as a GED tutor to other younger inmates?
Correct.
And so it is inmates like Mr. Terry that have created the opportunities for those other inmates to move on to better things once they get out.
And that will continue to be the process, and that is one of the processes that I was explaining that we are doing today. And I keep on saying we, it's my past profession, but I stay in contact with statewide classification. I'll stay in contact with the Secretary of Department of Corrections, kind of know what directions that we're going in, and that is what we do. We utilize inmate labor, inmate mentors, inmate educators to help us to train inmates who will be released. And the question was asked to me a few minutes ago, Mr. Terry is never going to get out, very probably. How is he going to benefit? Well, I don't know that he does benefit, but I know that he could probably benefit others with his education.
Now, when you say there was vagueness there, if he is sentenced to life in prison without the possibility of parole,
He ain't going nowhere.
it's not getting out.
No.
That's decided.
The only way he gets out is living vicariously through someone that gets out ahead of him.
But he's going to
He's going to be in that
He's gonna
prison
die in
for the rest
prison.
of his life.
right. You understand with life without the possibility of parole. Have you ever seen somebody sentenced to life without the possibility of parole?
EOS,
Is there an end of sentence?
there is no end of sentence unless the court changes that sentence.
Okay. Now, obviously the purposes of incarceration for somebody who is serving a 5-year sentence on a driving while license suspended or serving a 5-year sentence on drug dealing or theft, stealing a car, are quite different than the purposes of incarceration for somebody serving a life sentence without the possibility of parole. Would you agree with that?
I agree.
Life without the possibility of parole is severe punishment, correct?
Yes, sir.
Nothing further, thank you.
May this witness be released by the defense
Yes.
and by the state?
Yes, Ron.
Thank you very much, sir. You may step down. You may be released as a witness at this time.
Thank you, Your Honor.
You're welcome. Thank you. I'll ask the defense to please call your next witness.
Thank you. I got a second.
Yes, absolutely.
Defense call Steve Glassner.
Mr. Glassner, good morning and welcome, sir.
Morning.
He'll come forward to be sworn as a witness. You can wherever you're comfortable, if you'll face me and raise your right hand, please. Thank you. You swear affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. If you'll follow the bailiff down to the ramp that leads up to the witness chair, please watch your step. Go ahead, have a seat in that chair. Make yourself comfortable. The microphone in front of you is fully adjustable. You let me know when you're ready, and then I'll allow the attorneys an opportunity to ask you some questions. You might have to get closer to the microphone.
Ready.
All right. You may proceed, Mr. Kane.
Thank you, sir. Sorry. Just bang that. Good morning, Mr. Glassner.
Morning.
Can you sit a little bit closer to the microphone for me?
Okay.
Thank you. Your name?
Steve Glassner.
Okay. All right, Mr. Glassner, I know you're a little bit nervous, right?
Oh, yes.
All right. Well, as best you can, just pretend that you and I are sitting in the kitchen, okay?
Okay.
All right. And if there's anything that I ask you that you don't understand or you need some time to think, just say so.
Okay.
All right? Okay. Tell us a little bit about yourself and where you're from.
Holton, Michigan.
Okay. And how about your career?
I was an analytical technician, dealt with quantitative, qualitative analysis, and then I became a millwright. Over 50 years of working.
Are you retired now?
Oh, yes.
And you live on Big Blue Lake?
Yes, I do.
Where is that in Michigan compared to, say, East Lansing?
If you know, along Lake Michigan, White Lake, it's about maybe 15 minutes east of that, going east.
Okay. Now, sometimes we hear about the Upper Peninsula, right?
Yeah.
And so Holton, Michigan is sort of on its way up to the Upper Peninsula?
No, it's not.
Not on the
It's
way up
just
there?
just a little place.
Okay.
It's spelled Holton.
But if you're going from, say, East Lansing, more southern central part, and you're going to go up to the Upper Peninsula, you pretty much
We're
go
gonna
to...
go north.
Yeah. Okay. Now, you guys have lived up there for a long time, haven't you?
Since 1986.
And you guys built your home there?
Yes, we had a house built.
At some point, you guys met the Terry family, right?
Right.
Tell us about that.
When we moved out there, our children are about the same age, so they wrote.
Do you know Matthew Terry?
Yes.
There's some tissue there.
There should be, yes. You need a water? If you
No.
need a water, you let me know.
But anyway, they met on a school bus. And then, we live on the lake. So then they got together. So,
Do you see Matt in the courtroom?
no, I don't.
Matthew?
No, I do. Yes.
Okay. All right. Where is he? How long have you known Matthew?
Over 30 years.
You said that you guys met because, Matt sort of became friends with Johnny.
Right.
And about how many years were Matt and Johnny friends?
Oh, probably at least 20 years.
And Johnny is your son?
Yes.
And you also met the rest of the Terry family?
Oh, yes.
At some point, I guess the Terry family had a house right on Big Blue Lake.
Right.
You
Yes.
guys lived right next to each other?
Probably about half a mile down the lake.
Right. If you walk out your pier, you can see their
Yes.
property line
You can see it.
across the lake, right?
Right.
And about how often would you encounter the Terry brothers or Matthew? How often in your in your life?
Every day for at least 4 years. And then they moved back to Lansing.
When they moved back to Lansing, Matt was a little bit older.
Yes, yes.
Now, did Matt and Johnny continue to be friends?
Oh, yeah.
Something happened in 2010, 2011.
Yes.
Can you tell us what happened?
My son passed away.
Now, in going through that, obviously there were services for Johnny.
Yes.
Can you tell us how Matt played a part in that?
Matt eulogized my son's funeral. He talked about him.
Why would you ask Matt to do that?
His friend.
What kind of friends?
Good friend.
Do you think that Johnny's memory was well served with Matt's words?
Really.
What kind of person does a man have to be in order for you to ask him to send your son off with those words? What kind of man do you think Matt was to do that?
Respect. A lot of respect for him. Because they were just so close, they did everything. You know, everything, you know. All the activities on the lake, skiing, kneeboarding, ice fishing, hockey, you know, they just did everything.
Now, obviously, Matt's been facing some challenges at the moment. He's facing a conviction and he's facing a sentencing proceeding, and you're aware of that. Now, what is your view of Matt?
My friend.
Has anything changed?
No.
He's pretty much known Matt for most of his life.
Yes.
It doesn't matter how long you guys go without seeing each other. Does that in any way change how you feel about him?
No.
Thank you, Mr. Glasser.
Thank you.
Mr. Glasser, are you nervous?
Very.
Okay. You don't need to be nervous. I promise I'm not going to ask you anything tough, okay? I'm going to ask you some pretty common sense questions, I think. Was it hard to lose a child?
Very.
Is it hard to live every day with the loss of a child?
Yes.
Is it hard to lose a child unexpectedly?
Very.
You live on the Big Blue Lake.
Yes.
I had the good fortune to go up to Michigan a few weeks ago. It's a lovely place. And I imagine where you are, it's even prettier. You get to see the leaves change colors.
Oh, yes.
You have lots of great days of crisp, cool air where it's just cold enough that you put on a sweater, but it's not like you have to bury yourself in a jacket.
Right.
You get to step outside and you get to feel the sun on your face.
Yes.
Look at the gorgeous landscape that is around you.
Objection, Your Honor.
I'll allow some leeway overrule at this point. Let's
Is that right?
Yes.
Okay. And you know that you only have so many days in your life to do that, so you treasure those moments, right?
Yes.
Please understand I'm a father, so I can't imagine what it's like for you. I'm not going to ask you to think about that, but you said that you respect Matthew Terry.
Yes.
Did you know Kay Baker?
No. Personally, no.
Okay. Did he ever talk about her?
No. Not to me.
He never said, gosh, there's this girl I love. I'm crazy about her. I can't wait to spend my life with her?
Objection?
Overruled.
This is outside the scope of direct.
Overruled.
You ever say something like that?
Not to me.
Thank you, sir.
Redirect.
Nothing further.
May this witness be released by the defense
Yes.
and the state?
Yes, sir.
Thank you, sir. You may step down. You may be released as a witness for this matter.
Judge, could you approach the-
Yeah, absolutely, absolutely. Our morning break. It's 10:15, so we'll take our morning break. Please do not discuss the case amongst yourselves or with anyone else. Please do not do any research related to the case, and please avoid any contact with anything about the case. All rise for the jury. Please have a nice break. Jury has exited. Everyone may be seated.
Are we recessed, Judge?
Sure, let's take a 10-minute break. You need a break.
I just know if you wanted to put anything on the record.
No. is present. At this point, I think the best thing to do is just go ahead and get this witness on. Allow you all to, well, no, I need to do a colloquy. You want me to do the colloquy with him now, during this break, or after the witness?
After, Judge.
Okay, and I understand that. So,
Otherwise, you'd have to do it again after.
so well, I would tell him he can change his mind, but I'd rather do it with one. Let's just go ahead and get the jury and get this witness. I'll take a break. I'll take another break after this witness.
I'm sorry, did you want to address the issue about them recalling? Because we obviously would want to end with our witness, since this is supposed to be mitigation. And
We can
then
talk about
the
that
end.
now. Did you find cases?
I've looked in the entire country. There have only been 2 cases that mention the state even requesting something so extraordinary as reopening during the penalty phase, and in both cases, it was denied. There's no discussion of why. I can't give you specific law on the reasonings. I can just tell you, if you'd like the cites, there were 2 cases that it was denied in.
No, I trust you. We didn't find any Florida cases where it was, well, we didn't find any Florida cases where it was even asked for, but didn't find any Florida cases to indicate that it had been done. So to our knowledge, it's never been done before, is kind of where we're at. But I don't know that we searched other than Florida or Supreme Court. What does the state have, Mr. Dirt?
Judge, the issue regarding the state or the defense reopening their cases generally is within the
Discretionary
law.
issue.
Yeah,
So it probably can be done, but I think that the issue is clear that it's never, there's no indication that it has been done. And I trust Ms. Perry. Ms. Perry is one of the best researchers that I've seen. Also a good attorney, but the research is impeccable, and I trust her as an officer of the court that in 2 cases in the entire country where it was requested, the court exercised its discretion to disallow it.
But Judge, under Florida law, this court has broad discretion no matter what the proceedings.
I have the discretion. I have the discretion. The issue is how I exercise that discretion.
Right, and in cases where the cases make clear under page 779 of Earhart, and I'll read the cases, or it's clear in the cases, a very short version, as long as it is a timely request, as long as there is a reasonable explanation for the request, it doesn't relate to any new or different information being additional information, but it doesn't change the facts of the case, then the cases in Florida are that both on the state side and on the defense side, under those circumstances, cases have been reversed when the court did not exercise the discretion to do it. So it is completely permitted and reversible error if it's not permitted, if it's a timely request and there's a reasonable explanation for it. And so I'd just like to put the reasonable explanation for it on the record, if I may.
You may.
As the court recalls, and I repeated it this morning, we were about to introduce the transcript of the trial testimony
I still have the transcript right here.
of Kay Baker, and we had a long discussion and argument about that, and the court's final decision was, look, I'm not going to introduce the transcript, but I will permit the state to introduce the fact that the defendant, that Kay Baker, traveled to Michigan and testified on behalf of the defendant in the 2017 case involving Michelle Rogers.
I remember it well.
And so what happened was, that's the way it was settled, that's what was done. Opening statements began. Mr. Diaz made reference to that fact, and at that very moment, Mr. Kane asked to approach the bench. At the very moment he talked about that, there was a long discussion at the bench I presumed it was a discussion about the matter that Mr. Diaz had just brought up. I thought that issue had been resolved. I thought that's what was discussed, because that's what had been agreed upon by the parties. The parties agreed upon that.
My recollection is that Mr. Kane's objection was that he had exceeded what the agreement was as to what was going to come in, and I overruled the objection, and I allowed him to continue.
So I presume that matter resolved. I presume that was the agreement that we had reached in the parties. That's all we're at. So this has been a timely request. That's all we're asking for, is that single question be asked or it be stipulated to. And the state submits that's not an unreasonable, and the ends, as the cases in Florida require, it is an abuse of discretion if this court deprives the jury of information which will deprive the jury of information important to the ends of justice. We submit that this evidence is important. We submit that the parties have already agreed upon it. This was a change in the dynamics of how this evidence was going to be presented because the court withdrew that transcript. We didn't plug it in. I didn't remind Mr. Diaz about we needed to reassert that in the last question of the prosecutor. That's what happened. So I do appreciate your allowing me to put that on the record. We think the ends of justice require that the court allow that single question, which had been agreed to, be allowed before this jury. They've already been told about it.
Judge, the requirements are not reasonable explanation. It's good cause. And then forgetting is not good cause. That is not legal cause. The cases that they talk about in Florida have to do when the defense has requested to reopen and things need to get put in for a proper due process procedural defense, not in regard to the state. If they have a case that's been reversed where the state wasn't allowed to reopen, I would love to see it. I'm sure that they don't.
We do.
Additionally, it would not be in the penalty phase because, as this court is well aware, death is different. And there has never once in Florida been a state allowed to reopen a penalty phase in a death penalty case. And now they're trying to use non-death penalty case law, which is inapplicable because, again, death is different, and that is a legal standard that applies only to death penalty cases. There isn't one where this extraordinarily unusual request has been ever granted, and it shouldn't be done for the first time here.
What is the case that you said you have?
Judge, there's there's a case of Ellis.
Is this the one where the prosecution asked and it was a abuse of discretion to not allow it?
Yeah, it is.
Ellis? What's the site?
491 Southern 2nd, 1206. That is one case.
Well, I just want the one
That didn't come
they
up.
said.
I'm sorry, give the site again. That's coming up.
491 Southern 2nd, 1296.
Ms. Perry said she'd like to see a case, and you said there is one. Is that the case where she said she'd like to see one where the state requested and it was reversed as an abuse of discretion to deny the state the opportunity?
And there's a second, DW versus State, 40 Southern 2nd, Southern 3rd, 782.
Judge, I just opened it. It's a.
We're looking at it. It's okay.
Oh, you've got it.
We're pulling it up. So apparently that was a motion to suppress.
Right. Not even remotely.
There are all kinds of different concepts, but the concept is the same. It's denial of the trier of fact of information, like in Delgado.
All right, Mr. Dirks. I've heard enough. I'm not going to allow it. I'm not going to allow it.
Yes, Your Honor. If I could have a moment, I'm going to step outside and tell the witness she's free to go.
Okay. hard lesson, but it's what I've told my prosecutors in the past in less significant cases. They forget to prove ID or identity or venue in a case. It probably won't happen again. But they're not delivered. Are we ready? I'm sorry. Mr. Diaz, state ready?
Yes, Your Honor.
Defense ready?
Yes, Your Honor.
Let's get the jury. All members of the jury are present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, welcome back. Hope you had a sufficient break. We are going to pick up where we left off, and at this time I am going to ask the defense to please call their next witness. If you want to just announce the name, Deputy Manzi will get them.
Yes, thank you. Kathy Terry.
Kathy Terry. Miss Terry, good morning and welcome. If you'll come forward to be sworn wherever you're comfortable, ma'am. If you'll face me and raise your right hand, please. Thank you, ma'am. That's perfect. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes.
All right, thank you, ma'am. If you'll follow the bailiff now to the ramp, please watch your step, and that is an elevated ramp, so please be careful. When you get to that chair, go ahead, have a seat, make yourself comfortable. That microphone in front of you is fully adjustable. When you're ready, you let me know, and then I'm going to turn it over to the attorneys to ask you some questions. And unfortunately, you got to get really close to that microphone. You got to pull up and then pull the microphone down.
That work?
I think so. We'll let you know if we need to get you closer or talk louder.
Okay.
Morning, Ms. Terry.
Good morning.
Can you hear me okay?
Yeah,
Okay.
yes.
All right, you may have to sit closer to the microphone so that everybody can hear you.
Now I can't hear you.
Okay.
I'm sorry.
It's okay. I'm gonna move closer. Is that better?
Yes.
Okay. All right. Ms. Terry, could you identify yourself, please?
I am Mary Kathleen Terry. I'm my Matthews Robertson Terry's mother.
Do you go by Kathy?
Yes.
Do you see Matthew Terry in the courtroom today?
Mm-hmm. Yes.
Can you point him out for us? May the record reflect that Ms. Terry has identified her son.
Record shall so reflect.
How long have you been married, Kathy?
49 years.
Your husband is Mark.
Yes.
How many children do you have?
3 boys.
What are their names?
Matthew Robertson Terry, Luke Douglas Terry, and Peter Reynolds Terry.
Where does everybody live right now?
Luke and Peter live in Okemos, Michigan.
Is that pretty close to East Lansing?
It's about 8 miles.
Not too far.
No.
And have you lived in Michigan your entire life?
Yep. Yes.
So we've also heard from some friends of yours. You know Ben and Ruby?
Yes.
And they came down with you all?
Yes.
How long have you guys been friends?
Oh, let's see, probably 47 years.
So pretty much as long as Matt's been alive, you guys have been friends with the Williams.
Yes.
You know? And over the years, you guys have lived in different parts of the state, haven't you?
Yes.
What parts of Michigan have you lived in?
East Lansing originally. Then we moved to Detroit, Wixom area. And then we moved up to our cottage in Holton, Michigan on Big Blue Lake.
Do you still have that cottage?
Yes,
You still visit it from time to time?
all the time. I'm there most of the summer.
When you guys visit up there, do you have an opportunity to see Steve and Debbie Glassner?
Yes.
How long have you all been friends with them?
Probably 30 years.
You know, tell us a little bit about, raising 3 boys relatively close in age up there in Michigan. How was that?
Lots of fun, an adventure, a whirlwind at times. I was from a family of 3 girls, so 3 boys were a challenge at times too, but we had lots of fun, lots of activities. And I guess I just learned how to sort of get down on a boys type of level.
I'm going to show you some pictures if that's okay. I know actually, Donna, can you do that for me?
Do you want to show them to her first?
Yes.
I have no objection to introduction.
I will do that then.
And these weren't previously introduced. If you want
Defense
to move
1,
them
A
in,
through T as in tango.
no objection from the state.
No objection.
They'll be admitted. Defense 1A through T.
Thank you, Donna.
I believe that screen enough.
If you can, there's a remote or deputy sales group.
I'm going to readjust, if that's okay.
Yes, absolutely. You're
And
fine.
Kathy, if you want to position yourself so that you can see the screen behind you. And if you want to adjust your chair so you're more comfortable and not twisted. There you go.
Okay.
Is that more comfortable?
Yep.
What you might want to do is move that microphone farther down that way so you don't have to keep turning your head back and forth. It'll slide. So you slide it to your left.
We're snagged here.
Does it slide?
Yeah, there we go. There we go. Does it reach? Take the tape off. Oh, we have, oh, okay, there we go, okay. Can't do that.
You can slide it though, and you can adjust it, and then that way you might not
Okay.
have to keep turning your head back.
Okay, thank you.
And thank you for taking us through those, Kathy. Are you all pretty close?
Yes, very close.
And so when Matt started in the Marine Corps and then eventually got his degree in computer engineering,
Yes.
was he working in that capacity? Was he working as a computer software engineer
Yes,
after that, all the way up until
yep,
these things happened? And we've heard about the loss of Jessica and the impact that had on your family, and obviously you've seen that it's still very painful for you in these pictures. Yes.
very.
If Matt were to receive a life sentence, Kathy, would you continue to communicate with him and be a part of his life and be in contact with him?
Yes, I can't imagine any mother or any parent just wanting their child to die. You just can't stop loving them. And I would always I could not love him anymore. I will support him.
And we all appreciate and respect that there is that degree of pain on both sides. We understand the degree of pain that the Baker family has gone through.
Oh, I know. I'm just so sorry. I pray for them every day. And for Kay's children and sister and mom and dad and friends. I'm sorry. Just so sorry.
That'd be great.
Mr. Diaz, any questions?
Ma'am, do you need a minute?
Do you need a minute?
She's hard of hearing.
Oh, okay.
Yeah, just a minute.
Okay, take your time.
Okay. Thank you.
If I'm not talking loud enough, you tell me, okay? I didn't see Kay in the pictures. She wasn't there, right?
No, not at that time.
But Kay has stood by Matt, right?
Yes.
Through thick and thin. You gotta answer out loud.
Pardon?
You have to answer out loud.
Oh, yes.
Thank you, ma'am. She was his friend in high school.
Yes.
They maybe even dated for a time.
Yes.
They eventually separated. They went on with their own lives, but they stayed friends.
Yes.
Eventually, your son got in trouble in Lansing, ended up in prison, and she still would take the time and the effort to go all the way to Michigan to visit him.
Yes.
She wrote him letters.
Objection.
Yes.
Overruled.
She even went to trial and testified on his behalf, didn't she?
Yes.
When he got out, she started a relationship with him again, right?
Yes.
And eventually she invited him to come and live in her own home, to share the home that she has with her own children.
Objection.
Yes.
Overruled.
She was there for him whenever he needed her, right?
Yes.
Thank you, ma'am.
Redirect.
Nothing further.
May this witness be released by the defense
Yes.
and by the state?
Yes, sir.
Ma'am, you may be released. You may step down. Please watch your step. Ladies and gentlemen, jury, we're going to take a short break. There's some things I have to take up, so please do not discuss the case amongst yourselves or with anyone else. Please don't do any research related to the case, and avoid any contact with the case through any research or social media, or anything. It's going to be a fairly short break. We'll see you back in just a few moments. I just need to decide a couple things. All rise for the jury. Jury has exited. Everyone may be seated. So, I need to decide some things regarding schedule, but it may be more appropriate to address him and whether he's going to testify or not first, and then we need to talk about schedule.
That's fine.
Is he ready?
Yes.
All right. Mr. Terry, in an abundance of caution, just like I've done with all the other witnesses where there's a break, I'm just going to swear you in again, sir. If you'll raise your right hand, please. Thank you. Do you swear any testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, put your hand down. Sir, just like in the guilt phase, now we are in the defense case, and the defense has indicated to me that they have no other witnesses except for the possibility of you yourself testifying. That, again, is your decision and your decision alone. However, I do suggest that you discuss with your attorneys, that you consider their advice, and then ultimately you make a decision. So my first question to you, sir, and again, it is you can testify or not testify. I want to be very clear. I may have expedited it only because I indicated that it's the same decision like you made in the guilt phase. You are now making that decision again. Do you understand that? All right. So my first question to you, sir, is have you had enough time to discuss your decision whether to testify or not testify in the penalty phase of your trial with your attorneys?
Yes.
Have you made a decision?
Yes.
What is your decision?
I will not be testifying.
Okay. Has anyone forced you or threatened you in any way to make this decision?
No, sir.
Are you under the influence of any drugs, alcohol, or medicine that may affect your ability to freely and voluntarily make this decision on your own?
No, sir.
Thank you. I appreciate it. You may be seated. All right. So now let's talk about schedule. You're going to rest in front of them when I bring them out, I suspect. Well, yes. He's not going to testify. You indicate you have no other witnesses. So we're at the point where the defense rests. We've got jury instructions. We've got mitigating factors we have to go through, which I suspect
They're done.
could take a while.
They're done.
We're already gone through them.
Ms. Bradley was kind enough to send me all the ones she requested, and I gave them every single one they asked for. We've already fixed the instructions.
Oh, okay.
And
Have
we've
you
gone
sent?
over instructions.
I apologize?
We've gone over the draft of the instructions.
Have you sent that to us?
I just sent it to Mr. Diaz and Ms. Ismer because I wanted them to make sure that they
Okay.
don't have any other issues. I want to allow Mr. Kane also to have an opportunity,
Yeah.
but for the most part.
Okay, so when we have the charging conference, it's not going to last very long at all. Okay. Well, ultimately, once you've taken a look at it, I mean,
I already have it.
we can take.
Oh, I'm sorry. You meant them. Sorry.
No, I meant they said that they sent it to you so that you and Ismer could look at it
I've already seen it.
and send it to us.
No, they sent it to me for me to look at it. I'm not saying I've seen it. I agree with it. I think they're going to send it to you now.
Okay. Well, what I was going to say is once you've looked at it, send it to me.
Oh,
I
that's
don't
fine.
care who sends it to me.
The
He's
only-
indicated everything's good.
The only other thing we just needed to do was move on the verdict form, the paragraph down. That was it.
That's fine with me. If that's what the defense thinks needs to
Okay.
happen. I mean,
the paragraph, just
Okay.
that last paragraph that says if you did whatever,
I'm
just
gonna
move
make
it
the-
to the next page, that's all.
I'm gonna
And
make
we'll
the
have
final-
once we get it, and I have it in front of me, we'll have an official charging conference where I can flip through and everybody can agree on the record as to the instructions. What I'm understanding is that that's not going to take very long. It is 11:30. I'm going to give you all a choice. It sounds like you all have discussed. There is only two choices. They are not going to begin deliberations today for a number of reasons. Number one, they weren't told to pack a bag. Number two, we didn't secure hotel rooms for tonight. So if they were to go into a point where they needed to go, we don't have hotel rooms. They're not deliberating today. They are deliberating tomorrow. The choice is, do you want to give your closing arguments today, send them home and allow them to begin deliberating tomorrow morning, or do you want to give your closing arguments in the morning and then send them out to deliberate after closing arguments? Those are the choices.
Given the seriousness of the case, I will defer to whatever the defense wants.
Appreciate that.
Judge, and I understand if those are the only two choices, however, I would like to propose a third, which is if we were to waive sequestration, we could do charging, closing, and have them start deliberating since it is so early. And we have discussed that with our client.
They have indicated all week long, and frankly throughout the trial, willingness to go late. There's never been an issue with that. Obviously, the court will allow them to go as late as they want in the evening. I guess as long as the court doesn't have any issues. I know sometimes you teach.
I do, but I'm fine. This is much more important than that. No offense to the school I teach at.
We discussed that issue at length, given when we've rested. We've discussed it at length with our client, and I believe, we would prefer to do closings and instruct them, since we have gone through the jury instructions and it's not going to take that long, and allow them to deliberate.
Okay. I never say never. I honestly, when you said you had a third choice, I didn't think there was any possible. I didn't think there were any third choices, but you changing the a little bit, because you had said the other day that you wouldn't waive. So yes, with that change and the waiver of sequestration, it accomplishes both of my issues, because I didn't tell them to bring a bag, and
Right.
if they go, I'll go as late as they want. We've been here till 2 o'clock in the morning in this courtroom while a jury was out. I offered to let them go home. That wasn't a sequestration issue, and they wanted to keep going. So I will go as late as they want, or if they want to go home and come back tomorrow, they can do that. But let me just make sure that you are waiving sequestration on the record, and I think just in an abundance of caution, I'll verify that with him.
I agree, and that's fine. We've discussed it, and I believe Mr. Terry has been informed of the issue of sequestration and waiving it, and that he's okay with that decision.
All right, Mr. Terry, I don't need to go into a whole, all this stuff. I just went over a bunch of stuff with you. But are you in agreement to that decision?
Yes, sir.
And did anybody force you or threaten you in any way to reach this decision?
No, sir.
All right, I appreciate it. Thank you. That's good enough for me. So then, let's do it. Let's figure it out now. So I hadn't. I had considered that we would do closings. We do need to do the. It's 11:30. Should I give them lunch? Bring them in. Let
Yes.
you rest. Give them lunch. Then we'll do our charging. We'll be ready. We'll bring them back. If I give them lunch at 11:30, I bring them back at 12:45.
Is that enough time for June?
Yes.
If you want 12:45 or 1.
Well, 1 o'clock might be better because I have a.
That's fine.
Yeah,
That's fine.
we'll get
Let
it.
me ask, Mr. Diaz, approximately how long is your closing? You anticipate? Hour less? Hour more than an hour?
Less than an hour. Less than an hour.
Less than an hour.
Same.
Perfect. 1 o'clock. I'm going to bring them in, allow you to rest, send them to lunch. Let's get them.
And I'll send you the instructions.
Please. Thank you. Feel bad that I haven't had an opportunity to provide them a court-provided meal.
Now you
It's
can.
too late. No.
Now you
it's-
can tonight.
Yeah.
Yes. Yes.
You can tonight.
Yes.
if they need it.
I don't know if they want pizza 2
I was
days in a
gonna say,
row, but
They did eat at Eddie and Sam's yesterday.
Chinese food's always a good option.
I don't think that's on our list. Nothing against Chinese food. But we have a very limited list that we have arrangements with. And it all seems to be pizza and sandwiches.
Oh, yeah, we do have Spain.
Oh, I didn't see. I just heard we have Spanish too.
Have it? Okay, for beverage.
But we'll have plenty of time to consider where we would order them dinner from, and it probably won't be pizza.
Is Mark Terry released?
Well, that was up to you. Yeah.
Did you hold him?
I'm not going to call him as rebuttal. So
Yeah.
Did you hold him? You held him, I think, yesterday. I don't think you released him yesterday.
I did not, but if you're resting, I'm not putting on rebuttal.
All right. All right. Yes.
All rise, jury in your courtroom.
Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, welcome back. It wasn't too long. I told you to take it'd be a short break. So I am going to turn, thank you and welcome back. I am going to now turn to the defense.
Defense rest.
All right, ladies and gentlemen of the jury, the defense now resting their portion of the penalty phase. The next phase is the closing arguments of the attorneys. Each side has said that their closing argument will last approximately or less than an hour, but it is 11:30. So what we're going to do, and that was really the decision that when I sent you out, that I had to make a scheduling decision. I'm going to send you to lunch now. I'm going to give you till 1 o'clock. When you come back at 1 o'clock, you're going to hear the closing arguments. I'm going to instruct you on the law, and you're going to begin deliberating the case this afternoon. So, I'm going to send you to lunch now. It's actually an hour and a half. It's the longest that I've given you, so you can stretch out farther on your lunch than Publix down the street if you wish. But it is very important that you not discuss this case amongst yourselves or with anyone else. It is also very important that you not do any research related to this case. And finally, that you not be exposed to anything about this case in the media, social media, print media, or anything else. So please be very careful. We will see you back here at 1 o'clock. Have a safe lunch, and we'll see you back. Have a nice lunch. All rise for the jury. final instruction in penalty proceedings, capital cases. It is, excuse me, 6 pages long, starting on page 1. So it's one instruction. Rather though than just, I'd rather go through it page by page. I think is the most appropriate thing. So let's start with page 1. And I'll get both sides because it's been worked on by both sides, so I'll get an approval from both sides as to each page. I'll start with the defense. If there's any questions, comments, this is the time. Don't hesitate. I do have one formatting change on one page, but I'll make you aware of it when we get to that page 3.
Well, I would prefer that we would please reinsert the spaces between where it says 1, Matthew Terry was previously convicted, and then it starts the crime of assault with intent to do great bodily harm. I would also ask that we put the spaces back in between first-degree murder was especially heinous, atrocious, and cruel, and then did the definitions of heinous, atrocious.
Any objection to that?
No.
I'm sorry?
Yeah.
All right, yeah, I like that too.
Okay, so you also want a space between heinous, space between atrocious, and a space between cruel?
And a space between the one that says
And-
the kind of crime
okay.
intended.
Yep. So it's going to make it more than 6 pages, but that's
Yeah.
fine.
Okay.
I like spaces, and my staff attorney correctly pointed out that I'm less likely when I'm reading it to forget where I'm at if there's spaces than if they're on top of each other,
She takes such good care of you.
which is what we'll get to on page 3 that we're going to separate.
Page 1 of 6, no issues with the defense.
All right, let's look at page 2 of 6. Oh, I'm sorry, State.
Other than the request that I made that you granted, I have nothing.
All right, 2 of 6.
I don't have any objection.
I don't see any formatting issues that I have concerns with.
No issues with page 2.
Thank you. Page 3, I am putting a space in between each of 1 through 18, so they're not right on top of each other. So it's not single spaced. Those 18 mitigating circumstances, there will be simply a double space in between each mitigating circumstance.
And then a space between 18 and the following.
And then a
paragraph.
space between your decision regarding after mitigating circumstance 18, yes.
That's fine.
And I'm adding a period to the end of 7.
Thank you.
Yes, that's the only one that didn't have a period after Michigan University in 7, so there'll be a period there now. Other than that, and it's going to bump it, I mean, ultimately I'll let you all look. The language is not going to change, but it won't be page 3. That's going to take us on, these 18 are going to spill over onto page 4 ultimately.
And just
Right. I just want to look at it after you space it because that might impact like just taking it to a next page or something.
Oh, absolutely. We'll do our best, and then we'll give it to you, and if you have any changes, I don't foresee any reason why I wouldn't concede to your changes.
That's fine.
And for purposes of the record, I just want to confirm, I gave them everything they asked for. There's no other mitigators they want to ask for.
Is that correct? We've got 18 mitigating circumstances. Is there anything that they're additional that the defense is requesting as far as mitigating circumstances?
No.
All right. And all the ones that you had requested are listed in 1 through 18?
Yes.
Excellent. Let me know when you're ready to agree to page 3, other than the formatting changes we've made.
Agree on page 3.
State
All right.
agrees.
All right, we'll turn to page 4.
I don't really care one way or another, but it would seem like for uniformity, you should put spaces between the 1, 2, 3, 4, so on and so forth, but that's up to you.
I'm thinking I agree. Defense have a preference, issue? mind if we double space in between each number at the end of page 4, which also goes over to page 3? There's actually, 5. There's actually 8 things to be considered for credibility of witnesses.
I can take out 6.
Oh, had to be.
Well, we had 6 in the first round, so I would ask that we mirror whatever we had in the first round of jury instruction.
Yeah, since they can
Oh,
consider.
I see what you're saying. Okay,
Alright, so not taking out 6, leaving 1 through 8.
yeah. No problem.
And any problem with putting a space in between each number? Okay.
And then a space between 8 and a paragraph.
Yeah,
Yes.
I got it.
So does that mean that as 4 is current version of 4, state in agreement,
Yes.
defense in agreement?
We're talking about 4 or 5. Page 5.
Page 4 of 6.
Page 4 of 6, no problem.
Now we'll go to 5, which has the rest of that list of factors to be considered for credibility of witnesses, 5 through 8, which will now be spaced out, and a space after 8. And then we pick up with another list of 1 through 5, which are general rules, which I'm going to request a space in between. Any objection to spacing 1 through 5?
No objection.
All right. So go ahead and take a look at page 5. Any objection from the state?
No.
Defense?
Defense.
Nothing?
Nothing.
So that takes us to the last page, which, as I've said a number of times, is not going to be page 6 on the final version, but will be the final page, whatever number it is. State, any objection?
No objection.
No
Defense?
objections.
All right. Now let me just look for, where is the paragraph?
It's on the verdict form.
Well, is there not a paragraph in the instructions that talks about the verdict form?
I don't believe that there is.
Yeah, so there's no clear in these instructions where I show them the verdict form.
Well, I think you could probably do that after, in just a few moments, you'll be taken in the jury room by the plaintiff, by the bailiff, I'm sorry, when you have
Or it
reached
should be signed
decisions.
and dated. Yeah, okay,
Right?
yeah.
And then go straight to the verdict form from there, and then finish up with during deliberations.
I agree. So I'll turn to, it's just these instructions are slightly different than standard instructions. That is where, in the guilt phase instructions, there was a reference that said, and it is, the form has been created for you as follows. It doesn't have that. I'm not suggesting we need it. I will remember when I get to that I will then hold up the verdict form and read it to them. So let me just verify that page 6, was there any objection from the defense?
None other than, I think, the formatting that we discussed.
Right. We're continuing to space out any numbers and any paragraphs that follow the lists that are numbered. So now let's turn to the verdict form. I have in front of me jury verdict form, penalty phase. In the guilt phase, we had removed the hyphenated then guilt phase. I don't care. It's up to you all. If you do want to specifically include penalty phase on this one or eliminate it.
We'd like to keep it.
That's
Keep
fine
it.
with me.
Okay. Mr. Diaz, I apologize. You said you're fine with that?
Yes, Your Honor.
Okay. All right. So the title on the page will be Jury Verdict Form Penalty Phase. And then it has A through E. Page 1 is A and B.
Right,
What?
our only request is just to move that one paragraph down, that's all.
At the bottom, the if you answer yes.
It might make it a 3-page document, but I don't care if that's what the defense wants.
Well, if it does, we'll actually spread it out a little bit more so it's not just a signature on the third page. I don't want just the date and the signature on a third page. So we may bump down the title, and then we may put some space in between those introductory. I'll let you all take a look at it, and obviously, I mean, this isn't rocket science. So I'm flexible, but I just am not going to have only a signature line on the third page.
I agree.
fine with me.
We'll play with it and give it to you. It's easily fixable. Maybe we'll give you a couple versions. You pick your favorite version, and that's the one I'll slide in.
Well, I think also that this font seems to be something less than 10 or 11, I mean, maybe something less than a 12. If the font would be the same size as your final instructions, that might give you what you need on the third page.
That's true. I think you're right. I think that it remained in the 11 point, and we bumped the instructions to 12 points. So we'll do that, and that may, in fact, fix everything. And if not, I'm sure a slight bump down of the title or a extra space in between the introductory "We the jury find as follows" will satisfy that requirement. As to the language, though, that's the most important part. The formatting we can change on the fly, but I want to make sure that we're all on the same page, no pun intended, regarding the language on page 1.
There's no objection to the language of page 1.
I have no objection either. It appears to be standard.
All right, so let's turn now to what is now page 2. At the top is the mitigating circumstances. It appears to have all the instructions, and it says proceed, check only yes or no, and then the instruction, please proceed to section D.
No objection.
No objection.
All right, it looks good to me. Other than how when we increase the font and see what happens with that other change, we'll get it to you, but it looks like we're good on a verdict form.
My only question, do we usually leave that juror identification number on the signature block? Just that we just have.
No, where is that?
On
Yeah.
this.
And actually, I want 2 lines. I want signature and then print. So on this, and I'm sure this is just off of a standard form, but juror identification number, there's no need for that. Okay.
Right, I think that might be if there's some kind of issue with putting the person's name and they just want to do the number, so that's not necessary.
We
But I
didn't do that in
agree.
guilt phase, so I'm just gonna, but I am gonna include 2 lines. The first will be signature of foreperson. The second line will be printed name of foreperson. However it was on the guilt phase, it'll be identical.
Correct.
You want me to grab it from the clerk?
I mean, if they have it like right there, yeah.
Dee, do you have the guilt phase verdict form just like at your fingertips? Just like so. Thank you. And just so you all know, what it does is it says foreperson, and then in parentheses it says signature, and then the additional line says, again, foreperson, and in parentheses, printed. You got it? Sometimes when we're preparing a verdict form like this, I go ahead and insert the day's date rather than leaving it blank, but I'm not going to do that. We leave it blank so that if they return a verdict today, they can fill in, I believe it's the 17th, and if they continue over till tomorrow, they can simply fill in the 18th. So I'm not changing it, it's just as you proposed it.
Okay.
Is there anything else from the state?
No, Your Honor, I would just ask that your staff attorney, if she would email it to me on the lunch break, I'll print my own copy, so when I come back, I have it in the
Yeah,
end.
and we'll do the same to the defense. We'll email you that with the final. And anything else from the defense?
Judge, just since we have a few minutes before we close instead of doing it in the time before the jury gets back after lunch. We'd like to renew our prior motions regarding the denial of all pretrial motions. Some of them specifically affect penalty phase. Additionally, renew the objection to the granting of the state's cause challenge to juror number 105, who said she didn't know if she could impose the death penalty, as that obviously also affects penalty phase. Renew our objection to the denial of the motion for small voir dire. Renew our objection to the Williams rule evidence, and now for penalty phase, the prior violent felony evidence, especially because it became a feature of the trial, particularly with not only recalling Michelle Rogers, but also admitting photographs of Ms. Rogers, as well as additional testimony from Detective Krumbach. We'd like to renew our motion in regard to the ruling that if we were to get into information about the Williams rule self-defense, prior violent felony self-defense testimony of Matthew Terry, that would open the door to his conviction coming in, as well as renew our motion to the denial of the finding of a substantial violation and the finding of the prejudice for the Richardson issue for the state failing to disclose the jail call, as well as our motion for mistrial based on the issue where they failed to disclose that. All of those motions were previously denied. We are renewing them at this time. And I understand Mr. King may have something as well. We can do that at the end. We don't have to do it now.
Same rulings, but I didn't hear, maybe you said it and I just didn't hear it. There were, I think, 2 motions for mistrial during the guilt phase.
Yes, Your Honor.
And so you including that.
Well, as regard to the guilt phase issues as well, even though those don't specifically have to do with penalty phase, yes, there was also a motion for a mistrial because of Dr. Mendoza commenting on the defendant's right to remain silent. We would certainly renew that as well as our objection to the further limiting of the autopsy photos, as multiple photos were let in, which were voluminous and cumulative. There was also, of course, during the guilt phase, the denial of the motion for judgment of acquittal, as well as the renewed denial of the motion for judgment of acquittal, as well as a motion for mistrial because Michelle Rogers indicated that Mr. Terry had been incarcerated despite being repeatedly told not to mention that.
All right, same rulings as to all those motions as well. Anything else from the defense at this time?
No, Your Honor.
All right, have a nice lunch. Oh, wait.
I just emailed both sides.
She emailed it. Print out your own copies. If you see an issue, respond back to her email. Copy everyone so that we can try to address it, particularly if it's something everybody agrees on. Have a nice lunch. We'll see you back. I'll come in just a couple of minutes before 1. Hopefully all the jurors will be back.
So do you want us back at 12:45 or back at...
You don't have to come back 15 minutes before. I mean, it's up to you. I'm not going to come in until 5 minutes before.
Okay, I just want to make sure you were waiting on me.